Good morning. Thank you for joining us for today's webinar, Emerging Trends in COVID-19 Litigation and Practical Advice for Healthcare Administrators and Human Resource Teams. I hope everyone is doing well and staying healthy during this ongoing challenge with COVID-19. We recognize the extraordinary work that you've been doing through this crisis, and thank you for all that you're doing. I'm Wendy Johnson with the Pennsylvania Healthcare Association. Before we begin, I have a few housekeeping items to cover. PHCA offers monthly webinars to members to receive updates from department staff on regulations, learn from industry experts on current trends and practices, and to gain a better understanding of practical application tools to equip you so that you may continue to provide the highest level of quality care possible. This webinar is being recorded and will be made available on the PHCA website. The webinar has been approved for 1 continuing education credit for PHCA members. Credits will be uploaded to NAB within the next 2 weeks for those who have provided us with your unique NAB number, and I will be sending attendance certificates as well. A survey will be launched at the close of the webinar. Your feedback is important to us and our speakers, so please take a moment to complete the survey. All attendees will be in listen-only mode. However, throughout the presentation, please feel free to submit your questions using the questions pane on the right hand of your screen, and our presenters will address them at the end of the presentation. Today's webinar is being presented by Jeff Adler and Courtney Brennan, both with Burns & White. I'll now turn the webinar over to Jeff and Courtney.
Thank you, Wendy, and good morning, everyone. Just a few housekeeping things in terms of what we're going to do during the presentation. You may not know I am in the Philadelphia office, Courtney is in Pittsburgh, so we're going to do our best to keep things moving smoothly, but Courtney has her hand on the controls for the slideshow, so I think it will go okay. Another thing that I wanted to mention is we're going to take our pictures off of the screen now, so you'll have a bigger screen to see things and you won't be distracted by us. So let me go ahead and do that. Great. So this morning we're talking about a few things and just want to give you an overview on what you can expect during the course of today's presentation. We will spend some time talking about emerging trends in employment law and how the pandemic has changed things. And one point on that is that the change is ongoing. The rules of the road have not clearly been established yet, as many cases are going into the courtrooms and the courts are deciding things. I happen to notice this morning, I hope I'm not stealing any of Courtney's thunder here, but I happen to notice this morning a citation to a case in California where the court just ruled that a spouse cannot sue the employer of the other spouse for bringing COVID home and getting that person sick. So, you know, again, what we're seeing is every day there's a new ruling, there's a new court case, and things are moving pretty quickly. We're also going to talk about some considerations that employers should be aware of regarding COVID-19 related claims. And then we're going to get into some practical considerations for COVID-19 policies. Now, as with all employment-related presentations, we usually start by saying there's 2 things you need to keep in mind. And this is whether you're dealing with a COVID-related policy or any employment issue at all. And that is, number 1, be consistent. And number 2, write it down. Document what you're doing. With what we're seeing related to COVID claims and vaccine policies, et cetera, it's pretty hard to be consistent because every day you're seeing something different, and every day we're getting a different pronouncement of some type of change in the rules and what things look like for us from a business standpoint as well as from a legal standpoint. So hopefully we're going to give you some ideas that will be helpful, but the bottom line is just do your best because everything is constantly changing. And also, as I said before, that there have not been a lot of court cases from which to set forth bright line standards, and the court cases keep going forward. and we have to keep following those to see how things pan out. So at this point, I'll turn it over to Courtney, and she'll get into some of her presentation. Go ahead.
Thank you, Jeff. Good morning, everyone. My name is Courtney Brennan. And as Jeff just said, every day new light is shed on the parameters of some of these claims that we're seeing filed by employees. And as Jeff mentioned, we had a couple of cases that we were following where employees were sort of citing this family transmission type of claim against their spouse's employer. So while we don't think that is likely to be a successful claim, as the California court just issued its opinion on, those are still little parameters that we're following as we move through this litigation. And now that we're more than a year into the pandemic, we've been monitoring all of the types of risks that organizations and employers face, from regulatory compliance with OSHA, the various federal, state, and local agencies, as well as sort of the reputational concerns and, dealing with your employees' perception and maybe even a little bit of diminished morale as the last year has gone on. But certainly over the last year, organizations have been faced with making difficult decisions regarding, keeping their facilities running, taking care and providing care to patients or residents. And with all of that comes fluctuations in your employees' schedules and dealing specifically with employee requests. So we're beginning to follow claims arising out of the Families First Coronavirus Response Act, or the FFCRA, as it's commonly referred to. And you might recall that is the act that allowed employees to take sick leave and expanded family and medical leave for specific qualifying reasons related to COVID-19. So a lot of the cases that we're seeing being filed under the FFCRA relate to employees who, might allege that they were following doctor's orders or recommendations to quarantine, whether they felt maybe they were exposed to COVID-19 at work or through possibly even a family member. And what a lot of these lawsuits are showing are that, the employees claim that they were attempting to follow their doctor's orders, and as such, maybe their supervisor either instructed them to come to work anyways or made a comment that they felt they had to go to work. And a lot of times these employees did not show up to work. They were deemed to basically qualify as a no-show and were terminated. So while there's still ambiguity about how these FFCRA related claims will turn out, there still could be a violation under this act. And, the practical reality here for healthcare workers is that this was the hardest hit area of the pandemic. There was obviously a need to have your employees at work. And it just serves as a reminder to continue to have these conversations with directors, with managers, to not ignore employee requests or comments if they're acting upon doctor's orders. And, along the same vein, we're seeing a trend in cases involving retaliation or constructive discharge, where employees are alleging that, they asked for leave and in return were met with more heightened criticism at work, or even felt that they were forced to resign to protect their health or maybe the health of a loved one that they were taking care of. So, with the FFCRA, it's important to remember that although it expired on December 30th, 2020, the Act provides for a private cause of action. So the statute of limitations for these claims is 2 years from the date of the alleged violation, or 3 years for willful violation. So even if you're not providing the voluntary FFCRA leave this year, it's a reminder for organizations that, these types of claims could still be popping up from instances that happened a year ago at this point. Additionally, we've all experienced at this point standing in line to get our temperature checked or to sign off on the COVID-19 screening questions before we're allowed to enter either a store, maybe the doctor's office, or your place of work. But these screening procedures have invariably raised questions related to the compensability of time spent by employees undergoing such screening procedures, in addition to any possible compensation owed to employees who are maybe turned away after exhibiting COVID-19 symptoms. So what we're seeing is a lot of class action lawsuits starting to emerge where employees are claiming that the time that they've spent waiting in line for these precautionary measures is compensable. And more specifically, that the time waiting in line constitutes working off the clock. Now, this obviously would depend on a variety of factors, but a clear illustration of this is a case from a Wisconsin-based healthcare worker who filed a proposed collective and class action against an assisted living facility, alleging that this time her and her fellow employees spent waiting in line constitutes compensable time. She further attached a claim that the time they spent with their meal breaks was subtracted from their time on the clock. So these are the types of cases that we're seeing. They're not unique and they're not likely to go away overnight, but it's certainly the type of case to keep your eye on, especially for healthcare employers who not only have a duty to protect their own employees, but certainly the duty to protect patients. And where a non-healthcare worker may have an easier time arguing that such screening measures are not a principal activity where its employees are entitled to pay, the argument certainly gets a bit more difficult for healthcare employers who have to treat sick, vulnerable patients all the time. So the takeaway here is that there's a need to consult with counsel soon to determine whether your clock-in system puts you at risk for this type of claim, or otherwise make sure that your facility is accurately documenting employee time. Aside from the healthcare industry, we're certainly seeing these types of class action lawsuits filed against the big retail employers, Walmart, Amazon, and the like. So this is certainly a type of area to keep your eye on. Additionally, as I mentioned, with a lot of the concerns over the constantly changing, guidance issued by the regulatory agencies, as the vaccine has become more and more available, there's certainly more optimism, I think, out in the world in general, but also in the workplace. But with that said, we're continuing to see claims rolling in where employees are complaining about their employer's failure to provide safe working conditions. And that's where we're seeing really the bulk of these OSHA complaints. OSHA recently released guidance of the most common citations over the last year, and unsurprisingly, most of them have to do with healthcare facilities and the lack of PPE. But in addition to those types of whistleblower complaints, we're also seeing claims filed by employees who simply refuse to show up for work, as they, argued that they believed going to work presented a real danger of death or serious injury. Now, OSHA has announced this year in March that it's focusing its national emphasis program on COVID-related inspections and in-person inspections. And given the surge of this effort, we're starting to see lawsuits that are following suit here. Just this January in the Eastern District of Pennsylvania, a court ruled that 3 plaintiffs who were all former nurses of the defendant could proceed with a lawsuit alleging that they were wrongfully terminated for complaining that the company failed to comply with state and local COVID-19 orders. Now, the plaintiffs alleged that their termination violated Pennsylvania's clear mandates of public policy. And this is one of the first, if not the first, lawsuits to address the applicability of Pennsylvania's common law wrongful discharge in violation of public policy tort in relation to COVID-19. Now, while this is in its early stages and we're waiting to see how the court would roll on this, this opinion suggests that employees who complain to their employers about violations of state or local COVID-19 orders could be afforded some protection. So this does leave a bit of uncertainty. And given this uncertainty, employers should take care to continue, obviously, following the COVID-19 orders related to workplace safety, but to appreciate, the comments from employees and to not sort of brush those off and make sure that these comments are being appropriately addressed up the chain by managers and supervisors. So that naturally leads us into some of the considerations for employers regarding the vaccine, and specifically sort of the requests or comments you might receive from employees. So I'm going to flip it back over to Jeff to talk about the vaccine.
Thanks, Courtney. One of the things you want to think about as we're going through this part of the presentation, and I will go through some of the legal considerations as to whether or not you as an employer can require your employees to get a vaccine. But probably the bigger consideration and the bigger thing for you to address is, should I be requiring it? And that brings in a whole host of reasons why people are resisting the vaccine and so on. And I think that as you're developing your policies and your practices, again, you want to go back to the idea that do your best to be consistent and do your best to have those things in writing. Now, I'm sure that a lot of you are seeing surveys and polls of employees, of employers with all kinds of numbers every day. And I will make sure, if you haven't seen any yet today, that I'm going to give you a few of those. When I was looking at this, I found an article recently that was from actually it was last week, and this was a survey conducted by the National Federation of Independent Businesses. And of course, the first thing I loved was the article said, in April's survey, the 17th of its kind. So you can see that this organization is surveying its constituents on a regular basis. But the question they put forth was, what's your plan for vaccines for workers? And the survey revealed that 47% will neither require nor encourage it. 46% will encourage it. 3% will require vaccines. 3% didn't respond. And 2% said maybe they will require or encourage. So I think that as we're seeing, the decisions on whether or not to require vaccines are all over the map. And I think that's going to be a constantly changing metric as time goes on. The short answer to whether or not you can require a vaccine is yes. You can require your employees to be vaccinated with some exceptions. The two major exceptions are a religious exemption or a medical exemption, and that implicates Title VII and the ADA. So you cannot have a blanket rule per se in the event that somebody has some type of exemption. And typically what you would do as an organization, because you want to protect the privacy of your employees, that if you are going to require people to be vaccinated, that you would tell people who have a legitimate reason not to be vaccinated to take it up with the HR department. This is not something you typically want them taking up with their own manager. So let's look at the exemptions. As I said, there's the ADA and the Civil Rights Act. If you note that during the H1N1 flu, the EEOC issued guidance saying that employers cannot categorically require all employees to get flu shots, but they may be required to excuse the requirement for certain employees as a disability accommodation under the ADA or for religious beliefs, which is exactly what's going on with the COVID policies right now. So just a word about putting a policy in place. When you're putting a policy in place, I think one of the things you want to do is look at what your goals are. Is your number one goal the health and safety of your employees or of the residents and patients of the facility whom those employees are serving? Is your number one goal retention of employees, which is particularly difficult right now? In some places, in some companies, your goal might be maintaining a certain company culture or getting the culture back that you've lost during the pandemic. These things may conflict. Requiring the vaccine may promote health and safety, but may not promote retention of employees if they don't want to get vaccinated. And it's a very difficult question. And I think it's obvious, but you know that one size does not fit all. Another consideration that you need to take into consideration as you're going through this is that you have different types of employees within your organization. And you may have one set of rules for the employees who are having contact with your patients on a regular basis, and another set of rules for your employees who are purely administrative and have office jobs and don't necessarily interact with the residents. So those are things that you have to consider. And the question is, can you have different rules for different types of jobs? The answer is generally yes, but it is something that you really want to give a lot of thought to. So let's talk about the religious exemption for a second. Obviously, if someone comes in and says, I have a religious basis for objecting to getting a vaccine, the first thing that most employers think of is, well, what is that? And how do I look behind that? It's not like what you have when someone comes in with a medical reason and you ask them for a doctor's note. It's not like you're asking someone to bring a note from their clergyman. And in most instances, the requirement is that they have a sincerely held religious belief. And in most instances, the employer will just accept that. They will not look behind that. And in most instances, the courts are not going to look behind that. The other issue with the examination of this is that the employee has to prove that not getting vaccinated does not impose an undue hardship on the employer. So again, if an employee has a sincerely held religious belief and it does impose an undue hardship on the employer, you don't have to grant the exemption necessarily, but in that situation, it usually ends up with some type of end of employment. The employee quits and is now suing you for a constructive discharge, or you let the employee go because they're not coming in. And you have to be able to demonstrate that it would have been an undue hardship for you not to have that employee there. Okay, we can go to the next slide. Oh, you're ahead of me, Courtney. Okay. If the employee has a sincerely held religious belief, we're now talking about what is an undue hardship. And an undue hardship under Title VII is something that is more than a minimal burden on the employer. An undue hardship under the ADA, which we'll get to in a few slides, the burden is different. So what you have to show in terms of your needs to have that particular employee in place will be different from case to case. But for example, if an accommodation is requested that's going to have staffing shortages, cost more than a small amount of money to fix, or jeopardize the health and safety of others, it would likely constitute an undue burden. One of the things you have to do with all these is you have to engage in the interactive process. And that's usually a discussion. So you want to make sure you're taking really good notes. It is always going to be a she said exercise, but you can also engage in the interactive process by having an exchange of emails, and sometimes that may be better. The issue you face there is that you really want to sit down with your employee and have a sincere discussion about what are your issues, these are our issues from a business standpoint, and how are we going to get these things ironed out. But of course, if you do it via email, you're going to have a much clearer and documented exchange. The undue hardship under Title VII, again, I think you have to look at it and say, what is the vaccine refusal doing to my organization? And in most cases, for people who have residents or patients and their healthcare workers that are refusing to get a vaccine, that's clearly an undue burden. But then again, the flip side is if you require that vaccine and people refuse, are you going to lose staffing? And that's probably the biggest thing you go through as you're going through the thought process in terms of what you want to do. Sometimes the accommodation could be as simple as we're going to have the rules that we've all been living with, socially distancing, masks, etc. Now let's talk about the medical exemption for a minute. For the ADA exemption, employee has to show that it's an ADA recognized disability that prevents them from taking the COVID-19 vaccine. The ADA is become more liberal after the amendments of a few years back in terms of recognizing what is and what is not a disability. But the fear of getting sick is not necessarily a disability that would qualify under the ADA. It's more likely that somebody has an immunocompromised situation, perhaps pregnancy, perhaps a heart condition, whatever it may be. And obviously we're in somewhat of a gray area because I think we've learned that the doctors aren't sure exactly what medical conditions would prevent vaccines. But bottom line is, I think if someone shows up with a doctor's note, you are then deciding, does that fit into a ADA recognized disability under the way the statute is written? And then again, the vaccine does not impose an undue hardship on the employer. So you can require the doctor's note, and once you get it, it's most likely going to be determinative. Okay. Undue hardships under the ADA, as I mentioned before, it's a substantial expense or difficulty to provide the accommodation. That is a different standard, and it's very fact specific, and it depends on the nature of the job, the employer's business, the employer's resources. Those are all things that will be taken into account, but it's a substantial expense as opposed to a minimal burden, as we discussed earlier. Since the EEOC has declared that the coronavirus is a, quote, direct threat, and it's a significant risk of substantial harm to the health and safety of the individual or others, it cannot be eliminated or reduced by a reasonable accommodation. The designation gives employees more leeway, or employers rather, more leeway in what they can require. But again, you're back to, you have to go through the interactive process, and you have to make sure the employee is explaining to you what they need, and you have to look at what are there ways that I can accommodate this employee. Work from home is not necessarily an option for people who are dealing with folks in a residential setting, but it may be an option for people in your accounting department, as I mentioned before. Is masking, safety devices a reasonable accommodation? Perhaps. Is switching out shifts and things like that a reasonable accommodation? Perhaps not. I mean, those are the kinds of things that you're looking for and you're going through when you're dealing with the employees who do not want to come to work. If you are, who do not want to get a vaccine when you are requiring it. So the bottom line is, can you require a vaccine? Yes. Should you? That depends on what's going on within your business. And if you do require the vaccine, you will have to at least go through a process with people who are claiming that they cannot get vaccinated for one of the reasons we just talked about. Okay, let me kick it back to Courtney now.
Yeah, Jeff, and it's worth mentioning there was recently a claim filed in New Mexico. It was the first in the country where an employee was challenging, their employer's mandatory vaccine policy. And specifically was taking issue because of the fact that this is under the FDA's emergency use authorization, or the EUA as you see it commonly. Now, based on all of the guidance available to us, it's unlikely that this is going to be a successful claim, but it could be something that you hear an employee bring up. There's no suggestion that because this is the first time the country's been operating under an emergency use authorization, that it'll be any different compared to our usual full-fledged FDA approval. And if and when the full approval comes from the FDA, there's an entire body of case law from prior pandemics supporting an employer's ability to mandate the vaccine. So all in all, it's unlikely to be a successful claim, but worth mentioning in case someone brings up the fact that we're sort of operating under different rules with the emergency use authorization. Another area that employers could receive questions is whether there could be a potential workers' compensation claim if an employee has an adverse reaction to the vaccine. Now, the bottom line here is that this is a developing area of the law and very fact specific. And if an employer has a voluntary vaccine program and an employee were to have an adverse reaction, it's very unlikely that this would result in a compensable workers' compensation claim. But on the flip side, and this is a bit of a sliding scale, the more an employer is involved with the vaccine program and the employee, then it moves towards being a compensable workers' compensation claim. So you can see that coverage considerations include whether or not your program is mandatory or vaccine or voluntary, whether the vaccines are administered on company time, on site. But if all of these factors sort of line up with being controlled by the employer and the employee were to have an adverse reaction, then it is likely that this could be a workers' compensation claim. So just something to keep in mind sort of as we move through more and more employees within our organizations becoming vaccinated. Additional objections, and Jeff sort of touched on this, is that there's a wide variety of reasons that people may be hesitant or oppose getting the vaccine right out of the gate. But it's worth noting that in the past, courts have held that employees raising objections to a mandatory vaccine program for sort of just things outside of the exemptions that Jeff has discussed under Title VII or the ADA are not protected under federal law. So, it's worth maybe getting ahead of your employees as they raise these objections, and you might want to even work on communications that clearly outline and express that employees who are raising maybe social, scientific, or other non-religious, non-disability related views, that's not a sufficient justification for opposing a mandatory vaccine policy. Another thing to consider, though, has to do with the National Labor Relations Act, which does protect employees' rights to band together regarding the terms and conditions of their employment, whether or not your workplace is unionized. So that's just something to consider, and employers, need to refer back to their collective bargaining agreement. And even if the CBA permits employers to modify the terms of the employment agreement, absent an emergency, employers would still be required to provide notice and a meaningful opportunity to bargain about the effects of many of these types of prospective changes before being able to implement any of them. So these are sort of the considerations on the forefront that you might want to get out ahead of, and make sure that always sort of the best way to combat these questions from employees is by providing clear and frequent communications.
And I can't emphasize enough the idea that you do not want to look into your employees' motivations if it gets outside of the exceptions, because I think employees resent that and think, why are you in a better position than I am to determine what my politics should be, what my beliefs in science should be, and so on. Just to give you some additional statistics from another survey conducted by SHRM, which I'm sure you guys are familiar with, the Society for Human Resources Management. This one is from February of this year. And the first one was that, and again, from February till now, and of course, one of the things we said to Wendy when we were talking about this presentation back then is things will change in a very short amount of time and very quickly. But going back to February, in February, 33% of Americans believed that the COVID-19 vaccine should be mandatory. 28% of Americans who have been employed at some point during the pandemic would not get vaccinated if their employer required it, even if it meant risking termination from their job. So again, when you're setting policies, I think one of the things you're trying to consider is, what is my employee base going to think about that? That survey also found that when workers were polled, 60% of workers said they would probably or definitely get the vaccine once it becomes available. 24% of employees who are not planning to get vaccinated would change their mind if the employer offered incentives such as cash bonuses or stipends, paid time off, gift cards, etc. 12% of employees would be willing to get vaccinated only if they might otherwise lose their job. Obviously, the impact of offering incentives to your employees to get vaccinated is a lot different than threatening to fire someone if they don't. But I think you have to try to analyze and figure out what your own group of employees are likely to do and how you can best incentivize them. I will tell you that for most companies that we're advising, we are telling them you can require the vaccine, but we don't necessarily recommend that you require the vaccine. And that recommendation is mostly based on what we think is important for employee retention, but always we yield to the employer to know their organization the best. So what are some of the key takeaways from today? First of all, there's been an increase in the number of lawsuits filed against employers, and it will come as no surprise to you that there will continue to be an increase in the number of lawsuits filed against employers for several different reasons, among them discrimination, retaliation, FMLA claims, etc. And of course, you also saw the FLSA and those types of claims. Employers, you have to stay on top of this. You have to be cognizant of the fact that things change and you're going to have to be able to move quickly, to pivot, as they say, and do different things. Third thing is, as we can't say it enough, is document all of your employee requests, all of your employee complaints. Make sure that you have that information written down in a place that if it comes up, you can deal with it. If there's a lawsuit that comes up, you have that information. And, you know, continue to communicate with your employees as much as you can, get input from them, see which direction they're going. If you're setting up a policy, I would go through the following steps. Number one, set your priorities. As I talked about earlier, what is it you're trying to achieve with your policy? Secondly, make a policy something you can enforce and will enforce. It does not do you any good to have a mask policy that you don't enforce. I liken that to people who have cell phone policies, and we always see the case where someone gets fired for using their cell phone at work, yet that person, it was a policy that was only enforced against one person. If you can't enforce the policy, don't create it. If you can't enforce a policy that says people are going to wear masks in a certain area of the building because they just don't do it, then don't create it. So develop your policy, make sure it's something you can enforce. Anticipate some of the responses that you were going to get. One of the real challenges with mandating vaccines is that early on, before the vaccines were out, many people were designated as essential workers and were required to go to work pre-vaccine. And now people are establishing vaccine policies and saying, well, if you don't get the vaccine, you're fired. And the same person saying, wait a minute, you had me working for you for months without a vaccine. What's changed other than vaccine availability? The optics of that are terrible, and it's really hard to enforce that unless you're in a situation where, as I alluded to before, the type of workers are different because they have different jobs, be it administrative, contact with people, whatever. And lastly, be flexible. If circumstances change, it's okay to change your policy. But as you're making policy or changing policy, give people notice. People have to make accommodations in their own lives. If you decide, again, this may not apply to most of the folks on this call, but for a lot of businesses, as they're deciding to reopen and bring people back, you can't issue a mandate on May 25th that we're open for business on June 1st, because people have to make accommodations at home. They may have childcare issues. They may have transportation issues. They may be caring for other people, so have health-related issues. Give people as much notice as you can possibly give. And even if you are changing your policies, keep it written. And the policy should explain what your priorities are. Our number one priority is safety. Our number one priority is keeping the doors open, making sure that our business is operating smoothly. So at this point, I think I'll ask Wendy if you accumulated any questions.
Thank you, Jeff and Courtney. That was a lot of information, good information that you shared with us today. And we do have some questions in, but if anyone else has questions, please type them in the question box on the right hand of your screen, and we'll get to those. So we'll start off. I imagine there will be several questions, so let's start off so that we can end on time. The first question that we have is, if a facility decides to mandate the vaccine for all new hires or mandate as a condition of employment, what are your recommendations on how to handle contracted or agency staff if they are not required to be vaccinated? Can agency staff work at the facility if they are unvaccinated if the facility mandates vaccination?
Well, I'm assuming agency staff are people who are technically employed. They're probably dual employees. They're technically employed by an outside company, but are taking their direction from the facility. Is that correct?
I would imagine that that's the case, yes.
Okay. Well, I think that the facility can mandate as a condition of bringing in agency staff that they be vaccinated. And if not, you're just not going to accept them. And because the facility is the one that is responsible for and directing the activity of the staff person who's coming in. So if you're requiring vaccinations within your facility, you can apply it across the board, even to the people who are coming in on an agency basis.
Okay. Yeah, I think that's great. All right, so we have a couple more questions. The next question is, for vaccination exemptions, can we require the employees to submit documentation from their physician or religious leader to validate the requested exemption?
Courtney, you want to take that one?
Absolutely. The religious exemption is a little tricky because you can ask the employee to provide some type of, document, but it doesn't have to necessarily be from a person who's in the clergy or any type of leader, because the religious exemption carries broad application, not just to sort of the big religions that we might commonly think of. It also covers things that you might have never heard of. So with that said, you could ask them to provide you some type of document, but it can be as simple as sort of that employee's statement about what they believe. So, you might have expectations as to what that might look like, but courts apply this so broadly that it could simply be that employee's own statement explaining to you what they believe.
And the medical?
Yes, so as the medical, obviously you want to be careful when you're conducting screening questions. If you're giving the vaccine on site, you want to make sure that the people administering the vaccine are careful so as to not get into medically protected information or implicate. I know there's been a lot of questions about Title II of the Genetic Information Act. Generally speaking, the EEOC guidance has stated that as long as the individuals administering the vaccine or asking questions about the employee's health conditions don't venture into that personal information, it's okay to ask questions. But if an employee is submitting simply an ADA exemption and wants to provide their employer with sort of some backup documentation to support that exemption, that is fine.
Yeah, and just following up on what we mentioned earlier, that you can require someone to substantiate a claim for a medical exemption with a doctor's note, but again, that is something that you want handled discreetly with an HR person and not with a manager, or you just don't want medical information to be out in the public generally. I think we all know that's a good practice.
Okay, we have another question, and again, we are open for attendees. Please type your questions in and we'll get to them. We have plenty of time. The next question is, are there any violations to designate employees as vaccinated or unvaccinated on their name badge? For example, name badges are color-coded.
Boy, that's a tough question. I haven't really thought about that. I mean, certainly you can ask people whether or not they're vaccinated. You can collect that information. I would have to really look into that. My gut reaction is that you don't want to designate people as vaccinated or not vaccinated. Courtney, what do you think?
I agree, Jeff. I mean, we haven't seen these types of actions being put in place, but we can certainly imagine how that would impact the workplace and the facility's morale if it starts becoming sort of a finger pointing type of exercise, or you might eventually see employees claiming retaliation from something like that.
And I'll throw something in here from my experience or my interaction with Kalahari. Our annual convention is going to be held at Kalahari this year, and in my conversations with them, I know some venues are, giving their guests, some like bracelet kind of things, some bracelet type things where they're color coded as far as, red, I'm not I'm socially distancing. I don't want a hug. I don't want a handshake or anything like that. Yellow is like, well, I'm kind of in the middle, and then green, I'm open to, whatever it is. And Kalahari has told me that they are not doing anything. They can't stop us from doing it, but they are not doing it themselves, just for the reason of, possible discrimination. There could be, like you said, some retaliation, or, there could just be more issues that come about as a result of, some people being vaccinated and some not.
Well, Wendy, I have seen that happening in various events with the bracelets, but those are private events, and those are not employee situations. In the same way that we're seeing, if you read the paper, various colleges are mandating that students get vaccinated if they want to enroll at the college and attend school at the college, and that's not the same as a person who is an employee and has a different set of rights. So I think you can do those kind of things and ask for those kind of designations in other settings. I think the problem you have when you start color coding employee badges, that it's an invitation for if you're promoting vaccines, it's an invitation for the non-vaccinated employee to make a claim that, aside from the fact that they were singled out, that you can't discipline them because they're going to claim that they were retaliated against because they weren't vaccinated when the company had a policy to vaccinate people. So that's a very slippery area. I would be very careful about having people be designated in the workplace. But I do understand that in private settings, why that's happening. And I don't think there will be as many legal pitfalls if it happens in private settings.
Great. We don't have any more questions, but again, if anybody has a question, please feel free to type it in. I just want to give a quick plug for our summit. Our Assisted Living and Personal Care Home Summit will start off next Tuesday, May 18th. Check the PHCA website for more information. We've got a great lineup of speakers that will be speaking around leadership. There's some census building, and again, it is really geared toward any long-term care employee this year versus just the assisted living and personal care sector. So check that out. It's a great program. We're very excited about it. And then we won't have any more webinars scheduled because of the summit until early June. So we've got two webinars scheduled for June. So look for more information as those come out. Our next education update email will come out on May 18th. So next week, look for it, and then we'll have our webinar schedule for June and going into July. All right, I don't see any more questions. So just a reminder to stay on to complete the survey. Today's webinar recording will be made available on the PHCA website, and be sure to, again, check out the scheduled webinars going into June and July, and we're going to add more, obviously, for August and September as we get into some things. We're hoping that we can start offering some more less COVID-related or non-COVID related webinars starting soon. Again, I want to thank Jeff and Courtney for their expertise today. Thank you so much. It's constantly changing. When we talked about this back in March, which is hard to believe when we started this conversation, there's been lots of changes since then, and I'm sure if we were to have this tomorrow, there would be even more changes coming into play. So, stay tuned, and we'll keep you guys up to date as much as possible. We do have resources here at the association. Feel free to reach out, and then we will reach out to our business partners such as Burns and White. So I just want to wish everybody a great remainder to your day, and stay well, everybody.
Thank you.